All right. Briefly.
May I stand, Your Honor?
You may, or you may sit either way. I don't need a 20-minute exposition on the Constitution. Okay? I'll give you a minute, and that's it. Go ahead.
I believe, Your Honor, it's an injustice I am here at all. There's certainly more important cases. This almost became a jury trial. I believe the two bad sides here are Osir Krebs because he violated my Fourth Amendment rights, and Joseph Slicker because they are selling bad products. Mr. Kane is my adversary.
Now just a minute. Let's stick to the facts and to the law applicable to the statute, otherwise sit down. I'm not here to listen to you expound on life's problems that you have or experienced or on your philosophy of life. Either talk about the facts and the statute or sit down. I don't have the time for all of this.
There are two components of this case, the facts and the application of the law, how the officers—
Good point.
use the law. The facts, I do not believe they prove beyond a reasonable doubt. A reasonable doubt, they have to prove beyond they have to do a big job. I believe there is plenty of doubt today. Not even the owners of the bar were able to testify. Name deleted, was not able to testify. They were able to find no independent witnesses. I also tested I did not call her fetal alcohol baby. I would like to address the law. I examined this law. I believe this law is very subjective, vague. Additionally, I read some Court of Appeals decisions which in one case there was a defendant who called lots of obscene names to police officers, but the Court of Appeals in Minnesota ruled there was no imminent physical harm. None of the offenders testified I called them obscene names or threatened them. Furthermore, we have to specify what we are referring to as harass, abuse, offensive, disturb, reasonably alarm, all of these very subjective words. The Supreme Court ruled they cannot use the laws to combat rudeness or for social engineering. Even if I did call her that could be considered rudeness because they testified I did not prevent traffic flow, I did not prevent customers from entering the shop. Also, social engineering is something very important to look for. They are afraid some people like Joseph Slicker are going to use the police to get somebody from doing perfectly legal behavior. That is, of course, not right. There is nothing in what I did or what I said which would lead someone to provoke imminent physical harm, and that's a key phrase. They ruled imminent physical harm. Even if I did say what they said, which is seriously questionable, I also believe there's a very sad, cynical view some of us have about police and disorderly conduct. There's that view that they just use disorderly conduct because they can't find anything else to throw on you. That is an inherent problem of a law as vague as our disorderly conduct law is. Furthermore, I would like to address not talking to police. There is nowhere in that law which says you have to talk to police or even have to identify yourself. Why didn't I talk to police? Number 1, I believe rights are intrinsically rewarding to assert. I believe our constitutional rights. Thus, even if I have bad reasons for not talking to police, even if I'm irrational, I don't have to do it. I have good reason. I've had lots of bad experiences. Furthermore, I am aware of my rights. I realize my rights are very important. I'm doing my part to make sure these rights are preserved for everyone.